If you're trying cases, you know how frustrating it is when the other side comes up with defenses which you think are frivolous and they pretty much bring them out of nowhere. But what can you do about that before the trial starts? Well, I'm Saul Gruber at Gruber Trial Consulting, and one of the things we do is help lawyers prepare for cases and get them ready for trials. And one of the things we always say to our clients from the beginning is try to determine every single defense that the other side could possibly have. Even if you think that it can't apply to your case, even if you think that it makes no sense, still anticipate every defense you can. So how do you do that? Well, you can sit down some quiet time with a police report in front of you or a medical record in front of you and start to think all the things they're going to say. When I say there, I mean the other side, as to why they are not at fault. And you know as well as I do that when you get to trial, there are so many things being thrown at the wall, just hoping one stick. So rather than wait to trial, start at the beginning of handling the case. Come up with every defense based on your experience, based on talking to other people, other lawyers, and just other lay people, maybe even do a focus group, and put them all on a list and start knocking them out in discovery. What do I mean by that? When you're taking depositions, bring up the potential defenses and have the defendant or their employee say, no, that didn't happen. No, that couldn't have happened. And systematically get rid of each and every one. Now, some you're not going to be able to get rid of, right? They're going to be the true defenses, but you're going to deal with them in discovery and minimize them and limit them. Because really, isn't that what your depositions are for? Isn't that what requests for admissions are for? You're not trying to find out what happened in the case. By the time you're in discovery and filed a lawsuit, you know what happened. What you're trying to do is learn what the defense is saying and then systematically get rid of each and every defense. Because then when you get to trial and there's an expert testifying against the plaintiff, you would rather be able to show them depositions of all of the witnesses saying what the expert is now saying couldn't have happened. And then you're putting the expert against the employees of the defendant. That's always a much better position than scrambling to show that expert or those defenses are wrong. So remember, don't wait until trial to try to determine what the defenses are. Do it when you first get the case. And part of your discovery, part of your pre-suit checklist, part of your suit checklist is to get each and every one of those defenses minimized, if not diffused completely. Again, I'm Saul Gruber from Gruber Trial Consulting. If you have any questions or have any problems in getting your matter ready for trial or going over some ideas, give us a call. We're here to help.